quick little bit to make sure that the stream is fired up and working across the internet. If you're not a regular of the program, you may not know this, but we do actually multi-stream, which means we send this show, we broadcast it all around to different parts of the internet on Facebook and Twitter, Periscope, and Twitch even. But the most important platform is, of course, going to be YouTube. And Miss Faith just gave me the confirmation that we look like we're alive and well. So let's get started. Hello, everybody. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful, sunny Scottsdale, Arizona, where my team and I, over the course of many years, have helped to represent thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our criminal justice system. I'm talking about misconduct involving the police. We have problems with prosecutors. We have judges not particularly interested in doing justice, and it all starts at the top with the politicians, the people who write the rules and pass the laws that you and I are supposed to follow. But when they're held to the same standard, sometimes they have difficulty doing so themselves. And that's why we started this program. It's called Watching the Watchers, because that's what we do. We want to shine that big, beautiful spotlight of transparency and accountability back down upon that system so that we can talk about, encourage, and hope for some meaningful change in our justice system. We're very grateful that you are here with us and a part of the program. Now's a good time to subscribe. We go live at this time every day of the week. We want to have you here. We'd also love a thumbs up and a share if you wouldn't mind, so we can get some people pouring into this live stream chat. We're about to go through some slides, a little bit of a presentation, some of the news of the day. And I want to remind you that we're going to share these slides with you. If you want a copy of them at the end of the program, they're going to go into our Discord server, which is where we chat. So head on over there and join us for the conversation. On the agenda today, we have a lot to talk about. A lot. First and foremost, I was gone last week on Thursday and Friday. Oh, how I missed you so. It was for a conference. It was, it was fine. It was good, but I much would have preferred to have been here with you. So the good news is we're back. We're ready to get rocking and rolling, and there's a lot of news that we need to get into today. We just learned about an hour ago that Bill Barr resigned. We've got his letter. We've got his slide prepared. We're going to go through that at the end of the program. But before we do, we need to talk about what's going on with the election. Today is Electors Day. The Electoral College voted across the country. We want to break down some of that news. We're going to talk about Pennsylvania. We're going to talk about Arizona. We've got some other states where people are voting for Donald Trump, the electors who've been nominated to represent the GOP. They're voting for Trump, even though Trump didn't win that state. I want to talk about what that means and what's going on with all of that. We have some of the rules from the U.S. Code we're going to talk about. Now that the votes have been cast, well, there's this whole process that they have to go through to transmit the votes over to the U.S. Congress in the House of Representatives. Then they're going to count those votes, and that opens up a whole nother can of worms. So I want to break down what those rules looks like, because that's really the next tier. That's the next thing that the Trump people are going to be latching onto in terms of, seeing if there's a possibility of maneuvering this election over into their favor. We have a little bit of an update from the Wisconsin Supreme Court. They gave us a ruling very recently talking about some of this indefinite confinement language that we've covered on this show. We're also going to talk about that new forensic report from Antrim County over in Michigan, a company by the name of Allied Secured Operations. They released a new forensic report and a forensic audit. So we've got a packed show. We're going to get into it. We have the live chat we're going to save for the end of the program. So as we're going through this presentation and this material, if you have a question, if you have a super chat, if you have something that you want to send, feel free to do that. I'm not going to be able to answer them right now, but Miss Faith will capture those and save those for me at the end of the program. And now, because we're in this new YouTube era, got to give you that reminder that YouTube and Google and those people who are a part of the tech platforms, they've all decided that Joe Biden has won this election. And so keep that in mind as we go through this. Now, a lot of this stuff I think is still pending. YouTube wants us to tell you Joe Biden won the election. So we'll do that. Keep the rest of what we talk about in context as we go through the material. All right, so let's dive right into it. We want to talk about the U.S. Code. The United States Code helps define what the electors should be doing. And as we know, the electors met. So remember, we all vote for president, but our vote doesn't necessarily go directly to the president. We have this thing called the Electoral College, which is designed by the founders. It's in our Constitution. We've been using it for a very long time. And they're the ones who cast the votes for the next president. So we as people, we vote Those votes will go into our states, and the states, through their Secretary of Elections, the governor, and all the different executive agencies that are empowered by the state legislatures, they are the ones who are processing those votes, and then they'll nominate different electors who will then go and cast their votes in the Electoral College, which then will be counted in the United States House of Representatives, which then is who determines who the next president is going to be. So that's a lot. We want to unpack some of that, and let's do so. So when we turn over to U.S. Code Section 7, we're going to see that it says here, this was passed on June 25th, 1948. It defines the meeting and the vote of the electors, which is what happened today. And you can see it's just basically one sentence here. It's not a lot. It says the electors of president and vice president of each state shall meet and give their votes on the first Monday after the second Wednesday in December, which is today. And this says next, following their appointment at such a place in each state as the legislature and the states shall direct. So it's following their appointment as an elector, which is based on what the states want to do. And the state legislature is the body in the states that does that. So this has all been done. This has all been settled. Most of the states have already nominated and appointed their electors. They're meeting today. They're casting their votes. And so ordinarily, in a regular year, normally what you would see is the electors, they meet, they cast their votes. It's in uniformity with the state. So if a state voted for Joe Biden, those electors show up, they cast their votes for Joe Biden. But it's not a normal year for us. It's 2020. And so that's not, why would anything be normal this year? Today, what we're seeing is, yeah, that is happening. The different electors who are appointed by the state governments to go and vote for the state candidate, that's all happening. So the Biden electors are voting for Biden, and then the Trump electors are voting for Trump. But what about, you may have been seeing some of this around on the news today, what about these other GOP states? What about these other Republican electors who are still voting, even though their state didn't go for Donald Trump? In other words, these electors are voting for Trump, but the state didn't go for Trump. That's kind of weird. Have you seen that? Well, it's happening today, kind of all over the place. This one comes out of Pennsylvania. See here that there was a press release that they posted on Twitter today. It says, breaking, the Republican electors cast procedural vote, seek to preserve the Trump campaign legal challenge. And you can see this was posted this morning, 11:30 a.m., December 14th, and it's from the Pennsylvania GOP. So at PAGOP, if you want to go check it out. And they have this procedural vote press release that they're talking about. They say, coming out of Harrisburg, Pennsylvania, at the request of the Trump campaign, the Republican presidential electors met in Harrisburg, and they cast a conditional vote for Donald Trump as president. We took this procedural vote to preserve any legal claims that may be presented going forward, says Bernie Comfort, who is the Pennsylvania chair of the Republican campaign. He says, this was in no way an effort to usurp or contest the will of the Pennsylvania voters. And they're hearkening back to this era in 1960 when there was this presidential election between President Nixon, who was declared the winner in Hawaii, and they're saying that the Democrat legal challenges they were pending, while they were pending, Democratic presidential electors, they met and they cast a conditional vote for JFK. And they were doing this just to preserve their future ability to make a claim as the election litigation moved forward. So kind of a clever move here. The Pennsylvania GOP is saying, look, listen, we're doing this just to sort of back things up because we don't think that as this continues to unfold, as more evidence comes to light, as more of these lawsuits continue to unfold, as more evidence is presented in front of the legislatures, they're thinking that maybe this thing is not so settled. And so as a procedural matter, what they need to do right now is go and cast their votes so that presumably in the future, when allegedly Joe Biden, when his votes are sort of invalidated, now their votes are a backup plan. And you sort of see this all over the law. You see these backup plans that are put in place in case something doesn't happen with the legalities as they're moving forward. So it's sort of a contingency plan in some sense. And you see this, a good example that I can give you from criminal law is when we're talking about DUIs. So when you have a DUI case and you have, let's say your blood alcohol content was way over the legal limit, say it's 3-4 times over the limit, and maybe it's just sort of at that high end level, but it's not quite at a high enough level where they can prove that high level. So let me give you an example. When we talk about DUIs in Arizona, one of the things that we talk about is the legal limit. Probably happens in your state as well. So at a 0.08, so let's say you have 3-4 beers, you're going to be above that legal limit, above a 0.08 level. The next level up would be above a 0.15. The next level up would be a 0.20. That means your blood alcohol content is over 0.20. Basically, 20% of your blood is alcohol. It's over that limit. And so when people come into our office and they're charged with a DUI, they're going to see 4 or 5 different charges on their DUI citations. They're going to see, well, wait a minute. I was charged with being over 0.08. I was also charged with being over 0.15, also with being over 0.20. Why am I being charged with 3 different DUIs? The answer is you're really not. You're being charged with 1 DUI, but if for whatever reason you have an amazing defense attorney like the ones that we have here, and you're able to argue that you didn't really meet that highest threshold, so you weren't over a 0.20, you were actually just under that, well, they don't want to dismiss the entire DUI. They don't want to throw out the entire case. So they'll just lose that top charge. They'll just get rid of the 0.20 claim, and they'll just default back to the lower level claim. So they're called lesser includeds. And so you can see the government sort of structures its statutes in order to take into account those differences that you'll see in the law. And it's a contingency plan. It's to say, okay, we're going to dump that high level 0.20 charge. It's going to revert back to a 0.15 and the 0.08 and the impaired to the slightest degree charge. And so it's kind of, it's not exactly analogous, but you can see here that they want to lose that in order to save the other charges. And it seems like this is what the GOP is doing around the country. They're just saying, listen, we're not trying to invalidate the will of the people. We're not trying to, manipulate anything or subvert the process, which we're going to get to, whether that's accurate or not. But they're just saying, in the event that something happens, at least our votes are there. At least they're sunk into the ground. They put a stake there that says we can come back to this if something goes wrong. Whether it does or not, we don't know, but at least they have that stake in the ground, and so they can go back to that. We finish up this press release. It says the conditional resolution states that electors certify their vote for the president and the vice president, quote, on the understanding that if, as a result of a final non-appealable court order and other proceedings prescribed by law, they are ultimately recognized as being the duly elected and qualified electors for president and vice president from the state of Pennsylvania. So it's just conditional. It's saying that we're certifying their votes, that if, as a result of a final non-appealable court order or other proceeding prescribed by law, if we count, then we count. If not, then we don't. But at least they have that in the ground. So they planted that stake in the ground. We're going to talk about what happens next, because now in Pennsylvania, you have these 2 different groups, these 2 different bodies of electors casting their votes. You've got the Democratic electors who cast their votes for Joe Biden, which is the declared election winner out of Pennsylvania. But you have this sort of kind of not really part of the program. You have this group of kids who weren't invited to the party. They're having their own party out on the sidewalk, and they're saying, well, we're going to vote anyways, whether you like it or not. And this is the conditional vote that we're going to be sending over somewhere. And so we're going to talk about what that means, because now we have these dueling votes that are going on around the country, and those all have to be sent somewhere. And then what is the person receiving those votes, which is the president of the Senate, which we're going to talk about. What are they going to do with them? We're going to look at the code, we're going to look at the rules, and we're going to see what that has to say about it. It's going to be instructive for us. Before we get there, let's talk about what else is happening. So out of Nevada, this is the GOP. They posted on Twitter this morning that said, history was made today in Carson City, Nevada. We have McDonald NV leads our electors in casting Nevada's 6 electoral votes for the winner of Nevada. And they have this little video that we're going to run through. Let's take a look at it here. As you can see, I didn't clip much of this. This was from the Right Side Broadcasting Network, and this is presumably the electors who are out of Nevada, sitting around on the sidewalk in front of the Nevada State something or other, and they're going through the same process. They're going through the same motions that the other people were going through in the regular houses, in the legislature for the local states. And so we can see here what they are doing. It's not particularly interesting, but let's take a look.
Nevada presidential elector, official ballot for President of the United States. You should write in your choice for President of the United States, and then you should sign your name where indicated on the ballot. Do that 6 times, and then we will turn those in to the Secretary.
And so what you're going to see here is they're just going to sign these certificates of ascertainment.
Donald J. Trump.
He's saying, hey, if you forgot, his middle name's J. It's Donald J. Trump. So you can see him. They're all signing state of Nevada, and they're just signing on this day, December 14th. And they're going to do that 6 times. So just sign all of the different certificates of ascertainment. And the reason why is because those votes, those different certificates of ascertainment, they have to go different places. They have to send, one to the governor. They have to send one to the federal district courthouse. They have to send two to the president of the Senate, and so on. I don't remember the specifics there, but these 6. There's a process for it. You don't just sign it or send a text. Hey, we voted for Trump here today in Arizona. There's a formal documented process that they have to go through in order for this to be legitimate and official. And so they're going through their little mock, thing on the side of the road here, right in the middle of the day, just sitting down and nominating, casting their votes, casting their ballots for the state of Nevada. We also see this happening out of Georgia. This is David Schaffer, David Schaffer says that because the president's lawsuit contesting the Georgia election is still pending, the Republican nominees for the presidential elector met today at noon at the state capitol today and cast their votes for president and vice president. Had we not met today and cast our votes, the president's pending election contest would have been effectively mooted. Our action today preserves his rights under Georgia law. And you can see it looks like this is the chairman of the Georgia Republican Party. So obviously an authority on what they're doing and how the Georgia law works. And so we'll take his word for that. I think that's probably accurate. If they would have just said, okay, you're right, granted that we agree, Joe Biden won this thing, we're not even going to cast our votes. Now let's say that, the courts do start winding some of this back. Well, there's nothing in place. There's no stake in the ground for them to sort of latch onto and say, see, we told you that this was a problem. So now rather than us, having to go back and call for a new election or any of those things, we've already voted, just count our votes. And we're going to see what this means because, like I said, both of these dueling electors, they're sending their ballots into the United States House of Representatives. So if they're both going there, what happens when they are received? They threw the ball on the other side. Somebody's got to catch it. And now they're catching 2 balls when they were just expecting 1. So we're going to go into that here in a quick second, but let's see what the Trump administration is saying about this, or what is his legal team going to do? You're seeing this all over the place. It's over today. That's the end of the day. Last week, YouTube and Google, they told us that no, it was actually last week. The date of on December 8th was a safe harbor deadline. They were saying that is free and clear. Joe Biden won on that day. Now they're saying, well, no, today is really the day. But Trump's people, they aren't saying that at all. They're going to keep on fighting this. They're going to take it into next year on January 6th. And even some people are saying January 20th. So let's take a look at what they had to say. This comes from the Epic Times over from Jack Phillips. He posted this today. He says, Pennsylvania Republican electors cast their votes for Trump and Pence, the GOP. And I clipped a little bit of this article. It says, Trump's campaign and his lawyers for other campaigns, they've mounted a series of legal challenges across the different states. We've covered many of those. The majority of those have been thrown out in state courts. However, today, a White House advisor, Stephen Miller, told Fox News on Monday morning that alternate groups of electors were being chosen in several states, claiming it would lead to Trump's reelection. And he says, quote, the only date in the Constitution is January 20th. So we have more than enough time to right the wrong of this fraudulent election, result and certify Donald Trump as the winner. He says, as we speak today, an alternate slate of electors in the contested states is going to vote. We're going to send those results up to Congress. So that's their plan. We're going to talk a little bit about that Texas case being dismissed here in a little bit. I have some comments on that, but largely it looks like they're kind of just giving up on some of the court stuff. They're going to say, we're going to take these election issues to the state legislatures, and we're going to be contesting this in the House of Representatives in Congress, which is, by Stephen Miller, by his own statement there. So let's take a look at the rules and see how that would work, because this is a pretty big claim. This happens kind of every year. Let's say election year, not every year because we don't have presidential elections every year, but every time we have a presidential election, we kind of have this conversation. We always talk about faithless electors. We always talk about, whether somebody's going to object and whether it's going to be a big spectacle in the House of Representatives. And I've got some clips actually of Joe Biden, who was the vice president, who was administering or going through this process 4 years ago in 2017. So we're going to show you some of that. We have another individual who was objecting. So let's take a look at that. Before we get there, though, let's look at the rules. So as we're going to see on this next slide, there's a lot here. There's a lot of rules that govern specifically the collection of the votes from the electors in the individual states, and then the transmission, and then the counting portion of how this all works in Congress. So when we go over here, we're going to see that we can start at section 1, and that's all about identifying and nominating the electors. But then we get here, this vote and delivery portion. It goes from section 7 all the way down to about section 14. So 7 different acts under the U.S. Code, or different statute sections under the U.S. Code that tell us about the voting. We have the meeting and the vote of the electors. I already played that or showed you what that said. It says that they meet today. The manner of voting, how do they vote? That's where a lot of the specifics about how many certificates of ascertainment to sign and so on, how, what needs to happen, how to seal and endorse the certificates. Then what happens if the certificates of the electors don't reach the president of the Senate? What happens if they're transmitted, but they don't reach? What happens if they don't go to the district judge? What happens to the messenger if they neglect their duty and they don't send over the certificates of ascertainment to Congress? So all of these different sections are talking about the voting and the delivery of the certificates of ascertainment. And largely it's pretty generic. It just says if there's penalties or if there's delays or if there's a problem that happens, somebody needs to be notified and corrected. I think the most severe penalty that I saw in there was on behalf of the messenger. If they don't deliver it, then they can be subject to a $1,000 fine. Not a huge deal. And largely I don't foresee any of those individual statutes being a point of contention. I think that all of this, the voting portion of this, the transmission portion of this is all probably going to be done more or less by the book. Pretty standard operating procedure. But the big questions come into play when we talk about counting the votes. So now that they've been cast over the between now and January 6th, they're going to be transmitted. What happens when they get there? That's where the bulk of our analysis is going to come into play. Many of these early statutes are largely, brief, a sentence, a couple sentences. But when we get to section 15 down here, it says counting electoral votes in Congress. And then number 16, we have the seats of officers and members of the two houses in joint meetings. We have the limitations on the debate in the House. Then we have parliamentary procedures at the joint meeting between the houses. So we have the Senate, we have the House who are going to come together and count these votes. And so I'm about to get into it. So this is your legal wall of text warning, because this is coming directly from the U.S. Code. This is section 15. Let's take a look at it. And once again, let me frame this out just a little bit. So now what we're talking about with this portion of the law is what happens when that ball is being caught. The states have thrown the ball over to the Congress. Now Congress is going to be receiving that. What's going to happen here? This is what the law says. This is what the U.S. Code says. Congress shall, in a session on the 6th day of Congress, or 6th day of January, sorry. This is the new Congress, so keep that in mind. This is the same day on the 6th of January where the newly elected Republican candidates, the ones who just ran, they're going to be seated on this day. So they actually get seated earlier than the president, largely so that they can be a part of this process. So Congress is going to be in session on January 6th. And the Senate and the House of Representatives shall meet in the House of Representatives at the hour of 1 o'clock in the afternoon on that day. So you can see it's very specific. The president of the Senate shall be the presiding officer. And who is that? That's Mike Pence. That's Vice President Pence, which is interesting. People are thinking, wait a minute, the person counting the votes is going to be the vice president? What if he just decides to throw some of those votes out? Or what if he doesn't count them? Or what if he does something to kind of muddle in the middle of this thing? That's who we're talking about, Vice President Pence. All right, the statute goes on. It says 2 tellers shall be previously appointed on behalf of the Senate and 2 on the House of Representatives. So these are tellers. These are people who are going to be handed the documents as they are opened by the president of the Senate. So all the certificates of ascertainment are going to be there. 2 different tellers, 2 from the House, 2 from the Senate, are going to be handed the ascertainment documents that are opened by Vice President Mike Pence. All of the certificates and papers that are purporting to be certificates of the electoral votes, which certificates and papers shall be opened, presented, and acted upon, beginning with the letter A. So this is detailing this process here. It's not a lot. The 2 tellers, they're going to be opening the ballots that are opened by Vice President Pence, all the certificates that are purporting to be certificates of the electoral votes, which is important language there, right? What is purporting to be an electoral vote? What is purporting to be a certificate of ascertainment? Well, presumably the ones that are obvious, the ones that, in Nevada, where they voted for Joe Biden, and the certificates of ascertainment say we voted for Joe Biden, and those, and those are transmitted through the formal channels of communication. They end up in front of the Congress. Now they open them and they say, yeah, these are purporting to be electoral votes. Looking at them, looks pretty good to me. We're going to go ahead and hand those over to the teller. This is Vice President Pence. Okay, that purports to be an electoral vote, a certificate of ascertainment. Going to give that on over to the teller. Well, now they open another one from Nevada. Well, wait a minute, that's weird. These were also transmitted through, I would say less than authentic or less than official channels of communication, but these are also certificates of ascertainment. But these ones are going for Donald Trump, because we just saw that all of the electors were casting their votes on their certificates outside of the Nevada State Building, whatever that happened to be. And they're saying, no, this election was fraudulent. We've been given some authority by the local state government to go and cast our votes. We think that these are true and correct. We're counting every legal vote, and we're voting on behalf of Donald Trump. So now Vice President Pence, presumably, could theoretically, right? There's mechanisms to keep those votes, I think, out of his inbox, let's say. They're not going to go into his email account. But if they were, or they're somehow ended up there, and he has two dueling, competing certificates of ascertainment, what does he do with those? Let's take a look at the statute. It says here that they're going to be opened, presented, and acted upon in alphabetical order of the states, beginning with the letter A, which means Arizona, we're in the top three. We're always getting kind of crowded out by those punks over in Alaska and Alabama, but Arizona's right up there. And Arizona is a contested state, so Arizona might be one of the first ones where we see some activity on January 6th. Said tellers, having then read the same in the presence and the hearing of the two houses, they shall make a list of the votes as they appear on the certificates. The votes having been ascertained and counted according to the rules, the results shall be delivered to the President of the Senate, which again is Vice President Pence, who shall thereupon announce the state of the vote with the announcement, his actual announcement, deemed a sufficient declaration of the persons, if any, elected to President and Vice President of the United States, entered on the journal of the two houses. So kind of a lot there, right? But the idea here is there's an inbox with all these different electoral votes and these certificates of ascertainment. All that President Pence has to do, open them up, open them, hand them to the tellers. The tellers make a list of the votes, hand back the total tally to Vice President Pence. He opens it and he reads it and he says, with sufficient declaration, this person is the next president, right? That's how it should work. Should be pretty simple, pretty easy. I'm going to show you a clip from Joe Biden where he did that and made the announcement on behalf of Donald Trump. Probably a painful thing for him to have to do, given his relationship and history with Hillary Clinton, who was Trump's opponent back in 2016. So that all happens. It goes according to plan. Not a big deal. But what if there is a problem? What if something doesn't go according to plan? Which why would it? Because the year is 2020. Let's go on. The statute is not over there. This was the part if everything is operating to normal operating procedures, but that's probably we'll see if it happens or not this year. Another wall of text. Let's break this down. It says, upon such reading, the President of the Senate shall call for objections, if any. So that means when Vice President Mike Pence is reading through some of these votes, he says he can call for objections, if any. Every objection shall be made in writing. It shall state clearly and concisely, without argument, the ground, and it shall be signed by one senator and one member of the House of Representatives. So 2 people. Now, this was, this is sort of the hurdle that I think a lot of these prior objections during prior elections have run into. Largely, you can always find members from the House of Representatives who are going to object to this. Remember, there's 435, I think, different representatives that are a part of the House, and when they go and it's a big group of people. You're going to have somebody in there who's willing to stand up and object to the next president. We're going to see here in a quick minute that Maxine Waters did this regarding Donald Trump, and she puts her hand in the air and she's waving around her written objection, saying, "Is there any senator who's going to come out here and join me on this thing? Come and help me. Donald Trump's going to ruin America. Come join me in my objection." But she couldn't find anybody from the Senate to do it. Senate's a much smaller body. We have 100 senators in there. And so, they have longer terms. They have a little bit more, I would say, political, investment. That's usually a jumping off point to be president or governor or something else. And so, it's harder to get a senator to join on to one of these objections. But you need one of each. You need one representative. You need one senator. Then when that happens, they can make a formal objection. What happens next? When all objections so made, when they're received and read, the Senate shall thereupon withdraw, and such objections shall be submitted to the Senate and to the House, and they're going to break. No electoral vote or votes from any state which shall have been regularly given by the electors whose appointment has been lawfully certified, from which and so on. But the two houses, okay, a lot of difficult legalese here, a lot of commas, hard to kind of piece together what they're trying to talk about. Underline here in red, I said the two houses concurrently may reject the vote or votes when they agree that such a vote or votes have not been regularly given by electors whose appointment has been so certified. So this is kind of the takeaway from this entire statute. If in this situation you have an objection, which means a House of Representative and a state senator agree in writing that there is an objection to one of these states and one of these buckets of electors voting, even though those votes have been ascertained, even though they've been certified, even though the documents are in front of the House of Representatives, if both two houses agree, they may concurrently, or if they agree together, they may reject the vote or votes when they agree that they have not been so regularly given by electors whose appointment has been so certified. Okay, that's it, right? So they can object to that, and those votes cannot count. If more than one return or paper purporting to be the return from a state, think about this, right? If more than one return or paper purporting to be a return from the state shall have been received by the President of the Senate, this is exactly what we're talking about. If more than one that is purporting to be a return has been received, exactly what we're talking about here today. Right now, we have Nevada, Pennsylvania, Arizona. We have the formal electors casting their votes. We also have the Trump electors casting their votes. This is exactly on point. It says if more than one of those happens and they're received by the President of the Senate, those votes and those only shall be counted, which shall have been regularly given by the electors. Okay, and they're going to refer you back to Section 5. If the determination in the said section provided for shall have been made by such successors or substitutes in the case of a vacancy, if they have been appointed to fill such a vacancy, and so on. So they're saying that if they receive more than one, they can take the one that is legitimate. So they're going to go through this process and they're going to say, we're going to determine whether this was done regularly. Right? See that language here? Again, old language, difficult to decipher, but they're going to count the ones that have been given regularly. So the alternative argument would be that, they're claiming that the ones that are official are not regular, that those aren't officially certified, that those were cast on the back of a fraudulent election, is how the argument goes. The statute goes on, and this is going to be the last wall of text. It says, in case there shall arise the question which of two or more of such state authorities determining what electors have been appointed, the lawful tribunal of the state, the votes regularly given, and only those of such state shall be counted as the electors of the two houses acting separately shall concurrently decide is supported by the decision of such a state so authorized by its law. So that if the states agree, then those votes are going to count. And in such a case where more than one return or paper purporting to be a return from the state, if there shall have been no such determination of which, all right, then these votes and only those shall be counted, which the two houses shall concurrently decide were cast by lawful electors. So this is detailing essentially exactly what the process will be. It's very confusing. It's very complicated language. This is why people hate lawyers, because of paragraphs like this. Even I have problems with lawyers because of paragraphs like this. It takes a lot to sort of break this down and analyze it. But it says, those only shall be counted by which the two houses shall concurrently decide were cast by lawful electors, appointed in accordance with the laws of the state, unless the two houses acting separately shall concurrently decide such votes not to be lawful votes of the legally appointed electors. So this is saying if the two houses disagree about this, they're not going to count the votes. If the two houses shall disagree in respect to the counting of the votes whose appointments shall have been certified by the executive of the state under the seal thereof shall be counted. Okay. When the two houses have voted, they shall immediately again meet. Presiding officer shall announce the decision and the question submitted, and so on. So that's what you're dealing with, right? This is why This is why people in the media, this is why non-lawyers have a lot of difficulty sort of analyzing these types of questions, because it is difficult. It's not very clear. You know, I could rewrite this statute in about 10 minutes in a way that makes a million times more sense than this. But it's a bunch of garbled mess. But essentially what it's saying is, listen, these dueling electoral votes are going to come into the House of Representatives. There's going to be a teller who's ultimately receiving the votes from Vice President Pence. Vice President Pence is going to hand them the votes. They're going to count them. They're going to hand it back to Vice President Pence. He's going to open it up and he's going to say, okay, this is this. Now, at any time during that counting, that tallying process, anybody can object as long as the objection takes place with one member from the House of Representatives, one member from the Senate. They join together. They object to the votes. Okay, they say those votes were not regularly cast. They break. If you have one person from each of the houses who comes back in and they make the argument that those votes shouldn't count for whatever reason, those votes won't count. It's pretty simple. There's a lot of contingencies in here. There's a lot of of different ways and procedural sort of parliamentary procedures that take place. They have to break. I think they have to break the length of the debate. If you look at the other statutes, can only be for 2 hours. And so there are some formalities that they have to follow in that regard. But what we're seeing is, there is still a potential for this not to go by the book as many people may want it to. There still is the possibility that objections are raised during the counting portion of the process. And we're not there yet. That's not going to take place until January 6th. So is it over yet? Not really. Right? There's still some time there. Largely, yeah, the states have certified their votes. This is a huge ask if you're on Team Trump. There's a lot that needs to be done in order to convince a senator and them to make numerous objections as this goes through the process. I mean, I have not seen that, and I'm not real sure that they're going to be able to do that. But we will see. All right, let's take a look at what happened in 2016. Here is Maxine Waters, who is making this objection. Like I said earlier, though, she does not have anybody from the Senate to help her out here.
I wish to debate. I wish to ask, is there one United States senator who will join me in this letter
There
of
is no
objection?
debate. There is no debate.
That's one.
The gentlewoman will suspend. The chair has previously ruled a signature from a senator is required. Objection cannot be received.
All right, so there's Joe Biden acting as the vice president, the president of the Senate. And so you can see him there on the floor of the House of Representatives. You can see Paul Ryan back there with him, who was, I think he was the majority leader in the House at that time. And, they're going through the process. Maxine Waters was out there, trying to find a senator to go and help her join in objecting to the process. But, there's objections. And so I think largely what you're going to see on January 6th, probably a lot of objections. We're going to see a lot of this. You're going to hear a lot of this in the media. A lot of people are going to be complaining about this idea that, the Republicans and the Trump people are trying to steal the election and raise these objections. And we've never seen anything like this before. You're going to see a lot of that language, but we've seen it before. I just played it for you. It happened 4 years ago. Not that big of a deal. This is politics as usual, and we're going to see if it continues to be that way. Now, this is kind of a new administration and a new political landscape and a whole new ballgame. So we'll see if it is as orderly as it was in 2017. Here's another clip from Joe Biden where he is going through the process. And I didn't clip the full thing because he goes on for several minutes, where he actually does announce that Donald Trump won and he hits the gavel, and that's the end of the proceeding. But you can see even in the final minutes when he's going through and going to be formally announcing who the next president is, there are people protesting in the House. I mean, this is just kind of how it goes, folks. And let's take a look at what Joe Biden did in 2017.
Bernie Sanders of the state of Vermont has received 1 vote. Faith Spotted Eagle of the state of South Dakota has received 1 vote. The state of the vote for Vice President of the United States as delivered to the President of the Senate is as follows. The whole number of the electors appointed to vote for Vice President of the United States is 538, of which 270 is a majority. Michael R. Pence of the state of Indiana has received for Vice President of the United States 305 votes. Tim Kaine of the Commonwealth of Virginia has received 227. There will be order. Senate arms were removed. Senate arms were removed. From the gallery. In order. House. The Commonwealth of Virginia has received 227 votes. Elizabeth Warren of the Commonwealth of Massachusetts received 2. Maria Cantwell of the state of Washington has received 1. Susan Collins of the state of Maine has received 1. Carly Fiorina of the Commonwealth of Virginia has received 1. The Sergeant at Arms will remove the protesters from the gallery. The chamber will be in order. The change.
All right, so I fully expect that to happen again, and I fully expect there to be this hysteria about what a disaster this is for the country. Even though this happened, the Democrats did this in 2016, and you may not have been able to hear it because it's a little bit muted. But the woman in the background who's shouting about saving democracy, she's saying there was voter suppression. She says something, voter suppression, there's 100,000 this and 100,000 that, or whatever it is. So a lot of the same issues that we're talking about here, they were bringing up back in 2016. And so this is just the process. Politics at times can be blood sport, and it can be, a lot of, sort of energy and activity going on, but is the process going to go through the way that it should? And if you watch that clip in its entirety, Joe Biden goes through it, and he does exactly what we just described. He actually, pulls out, reads the ballots, he goes through, he continues to announce the final numbers for the different candidates, and he says, based on all of this, we've concluded here, Donald Trump is going to be the next president of the United States. Okay, boom, hits the gavel. That's the end of the proceeding. That's it. Now, could he do something else there? Could he have done something else? Yeah. I mean, he's the person with the gavel. He's running the entire spectacle. So, a lot of people out there are saying that, well, Mike Pence could theoretically do something here. He could, decide that he's not going to count one particular set of votes, or he's going to throw something out, or, bring in some obscure parliamentary proceeding rule, or do something that, sort of nobody's keeping their eye on right now. Something can happen is sort of the claim. I don't see that happening, folks. I really don't. Joe Biden went through this, put in Donald Trump. It's been going this way for a very long time. I think that Mike Pence probably has a lot of future political aspirations. I don't think that he's going to stand in the House of Representatives with that gavel and do something that is not ultimately what the majority of the country think is the will of the people. Whether you want to argue with that premise or not, that's a whole different question. Many people are arguing with that premise, and I think for good reason. But what we're seeing here is just this formal proceeding where the votes are counted, they're called to order, he nominates, or he actually makes that final declaration, and that's the point in time in which the next president is officially seated, by my reading of the rules. Now, we'll see if anything else changes, or, a lot can happen between now and then, but we haven't, this is sort of uncharted waters here. I've never seen anything like this. There's obviously, and there's not a lot of history on it either. A lot of people are going back to some of the 1800 cases, and they're going back to the 1960s, JFK versus Nixon argument. And we can kind of glean some tidbits, some little nuggets here and there. But largely, we are in uncharted waters, and we're going to see where this goes. And it could just be, it just goes as normal. They just go and read the votes, and Joe Biden's the next president. Could be, or not. We will see. All right, a quick little bit on the Texas lawsuit. So, last week on Friday, I was out at a conference, and of course, one of the biggest news stories ever happens. It is the Texas lawsuit, which we spent some time covering last week as well. I was dismissed by the U.S. Supreme Court. This was one where a lot of people thought that this was the best legal shot that Donald Trump and his legal team had at reversing the course of the election. The lawsuit was very, I thought, well put together. It was joined by a number of different attorney generals from around the country. We had, I think 100 plus different Congress people joined onto this. We had, people from around the country who are in positions of power, different aspects of the government, were all joining in on the lawsuit. And so a long time, if you've been a part of this channel for several months, or the last 6 weeks at least, we've been talking about this idea of legitimacy and the Supreme Court having to have legitimacy. And they dismissed this case. And I think it all comes back down to that buzzword, to that issue. Let's go through the order first. You probably have already read it, but this is sort of the the end cap on a lot of the litigation that we've been discussing. So I want to make sure we at least get some closure on this topic. So it says here, the order in the pending case, Texas versus Pennsylvania. This came from the Supreme Court late on Friday, December 11th. I was sitting in a conference and my Twitter went off and I thought, oh, what's this? Oh yeah, it's just the decision on the biggest case that we have been following on this channel for 6 weeks, and I'm not there to talk about it, but that's okay. Wasn't even upset about it, not even bitter a little bit. Here's the order. It says Texas versus Pennsylvania. The state of Texas motion for leave to file a bill of complaint is denied for lack of standing under Article 3 of the Constitution. It's kind of it. Texas has not just demonstrated a judicially cognizable interest in the manner in which another state conducts its elections. All other pending motions are dismissed as moot. That's the order. That's the full order. Statement of Justice order, with whom Justice Thomas joins. In my view, we do not have discretion to deny the filing of a bill of complaint in a case that falls within our original jurisdiction. I would therefore grant the motion to file the bill of complaint, but would not grant other relief. I express no view on any other issue. There you have it. That's it. Remember, we've been talking about this for a long time. A little bit of guidance from the U.S. Supreme Court would be helpful. A little bit, just a little bit of an understanding, because we have another election coming up. We're going to have a lot more of them, and it would be good to know what the Supreme Court's position is on these things, because even though you may not agree with some of the claims that have been made or some of the allegations of fraud or any of those things, wouldn't it be good to know what some of the rules are so that we can make sure that everybody's playing by the rules across the country? Well, the Supreme Court apparently thought no. They said Texas has not demonstrated a judicially cognizable interest in the manner in which another state conducts its elections, which you can understand the pros and cons of that type of a position. I mean, in my mind, the analogy that I was thinking of was when you were a kid and you would go into summer school, or you would have these competitions where you'd have to read a certain number of books in a summer, and whoever read the most books, they win the project, or they win the prize, they win whatever that is. A lot of adults will do that. New Year's is coming up. You may make a New Year's resolution that I'm going to read 35 books in 2021. People do that all the time. And let's take that analogy just a little bit further, and we say, all right, well, if everybody is on the honor system and everybody's saying we're going to read a book, and I'm going to write a book report, or have some sort of mechanism whereby I can validate my effort and my work, and I turn that book report into the teacher, then that's great. And everybody's doing that. The teacher has a universal standard. Everybody can just read a book, write a book report. We have one set of rules. Great. Everybody can be held to that set of rules. But what if the teacher doesn't require book reports and we all just kind of have to self-report? I read 10 books. Little Johnny read 5 books. But Susie over there, she read 45 books. That's insane. How much time? There's no way that she could read that many books. You remember these kids. And they would just submit everything, and they would win the prize all the time. And everybody's scratching their head going, did they really read any of those books? Did that really happen the way that they said it did? I got some suspicions about that. And so, for many people, you say, well, they're going to win the prize now. I was playing that competition. I played by the rules. Susie didn't play by the rules, and she's going to get more of the benefit than I have. And that doesn't feel fair. That doesn't feel right. And so from a natural kind of, that doesn't make any sense. From a natural understanding of how, fairness and things work in the world, you would want everybody to play by the set of rules. Because if one of these other children are not actually reading the books and they're just submitting their book reports, or one of these other states is just submitting their certificates of ascertainment, but the underlying election, the underlying reading never really took place, or it took place in a way that was constitutionally suspect. We have a constitution, which is the floor of how this stuff operates. And the allegation here is that many people were dropping below the floor. They weren't even reading the books. They weren't submitting book reports or doing anything. They were just saying, I read 100 books. Teacher doesn't care. Nobody cares. Supreme Court doesn't care. We're just going to turn all those in. And that's that. And the Supreme Court is essentially saying, yeah, do whatever you want, right? They're not even ruling on any of those issues. Not ruling on whether you can move election dates, whether you can waive signature requirements, or what any of this encroachment of one branch of government into another branch of government. In other words, one Secretary of State taking over some responsibilities of the state legislature, sort of just gobbling up power. One branch of government just gobbling up power from another branch of government. Supreme Court really didn't have anything to say about any of that. Just said, You can't raise a complaint. So we go back to the book analogy. What the Supreme Court, I think, is doing is saying we don't want this type of stuff to go on across the board. We don't want me reading 10 books to go after Susie and to say, I want to challenge every one of those books you read. I don't think you read them. So I'm going to challenge that. I'm going to drag your butt in front of the teacher. We're going to sit down, show me that you read that book, show me that you read that book, show me that you read that book. And now the teacher has to adjudicate all of those claims. What we're talking about here is a policy decision from the Supreme Court to say, listen, states are free to run elections the way that they want to. If you don't want to read the book, if you don't want to run your election properly, that's your problem. That's your problem in your local state. Individual citizens of your state, figure it out, fix it. If you don't want your votes to count, if you don't want signature requirements, if you're cool with the courts just moving the election days around wherever they want willy-nilly, if you're okay with, in Wisconsin, setting up an online portal where you can just go register to vote without uploading any of your driver's license or any of that information, no problem, free to do it. And guess what? Nobody can even challenge you about it. No state can even butt into your operations because we just said they can't. We just said that the Supreme Court doesn't have to accept these cases, even though in the Constitution under Article 3 standing specifically says that the Supreme Court has original jurisdiction over these types of claims. If Texas wants to sue another state, I mean, there is nobody else to resolve that dispute. They can't go to the court in Arizona and have Arizona say, yeah, we're going to resolve this between Texas and Pennsylvania. Never happened. It's the Supreme Court. They're the only ones that can hear it, but they refuse to do so. So two things. Number one, I think this was a policy decision more than anything else. They don't want a bunch of different states suing each other every time there's an election. And Lord knows that would happen. So I get it from that perspective. And I think it kind of makes sense. You don't want every time there's an election, a bloodbath of 50 states suing all the other 50 states. And if the Supreme Court entertained this lawsuit, that might be opening the door to that. And the other reason, it's just a legitimacy thing, folks. I've been saying this a long time. The Supreme Court, where the basis of their power is in this concept of legitimacy. They need to have the public sort of stamp a lot of their decisions. You don't see really unpopular Supreme Court decisions often, right? We've had them historically, but largely they're kind of in alignment with where the country's going. I mean, we saw this with, same-sex marriage, right? We saw that in that Obergefell decision. We've seen it a number of times in our history where even when you can go back to the days of slavery, right? I mean, the Supreme Court originally put a stamp on that. And then as the country continued to evolve, they moved beyond that and their jurisprudence evolved as well. And so, right now, if the common notion of who won this election is accurate, if that underlying premise here that Joe Biden won this thing is accurate, and YouTube says it is, then the Supreme Court would be doing a big disservice to themselves if they're overturning the will of a popularly elected president. So you have to accept that premise as being true. And if they were reversing that of let's say that there was no fraud and everything that took place during this last election was all legitimate, credible, and kosher, well, the Supreme Court would be invalidating the majority vote if they would accept this case and hear it. And so they're not going to do that because it would undermine their legitimacy. I made the same point when we were talking about Obamacare. John Roberts, the Chief Justice, joined with the left wing, I think solely for the purpose of maintaining the court's legitimacy, because I think they were too concerned about angering this wave of populist momentum that Obama flew into office on. It was his first domestic policy, and if he would have, if the Supreme Court would have taken his signature domestic policy and thrown it out the window, it would have really undermined the legitimacy of the court. And at that point in time, you may also remember, I think if the timing's right, Obama had the Senate, so he could have easily packed the court. And so, they make these things. They're supposed to be apolitical, but they're not. They're very, very political. As we know, every time there's a confirmation hearing, everybody gets beaten up over about how they're going to rule on the bench. And one final note, a lot of people are saying, well, that's ridiculous. We have Gorsuch, we have Kavanaugh, we have Amy Coney Barrett, who are all Trump appointees, and they didn't even put a sentence in this order. Not even a word. They didn't say a thing. What a bunch of backstabbers is sort of the argument that I've seen from a lot of the conservative Republican types all over the internet. And this is not something, look, you have to understand, if anybody thought that putting Amy Coney Barrett on the bench was going to be a rubber stamp vote for Donald Trump, I mean, I think you're just out of touch with reality just a little bit. You know, these people, their careers, their philosophy when it comes to jurisprudence is way bigger than any one individual, way bigger than any one president. So it's not a quid pro quo type of thing where they're going to just, get put on the bench and then suddenly turn around and support Donald Trump without any reservations. That's not going to be the case. And another interesting thing, this is something that is anecdotal. I don't think that this is the rule, but this happens enough that I think it's worth mentioning. Anytime you get a judge who is sort of on your side or has previously been on your side, sometimes you can get some of the harshest rulings from those judges. I've seen this in my own career practicing law. When let's say, for example, I'm representing a client who's charged with whatever crime it is, and we go into a courtroom and the judge used to be a criminal defense attorney. Okay, before he got appointed on the bench. And you might go, well, that's pretty good. This judge might have some favorability. He might understand the plight of the criminal defendant. He may know how corrupt and disgusting a lot of these prosecutors and cop offices are and all these things. So maybe we'll get a beneficial ruling on this. Doesn't always go that way, believe me. A lot of these defense attorneys, it's almost like they're compensating for the fact that they were a defense attorney. They're compensating by being overly harsh on defendants and being overly lenient on prosecutors. And sometimes it works in reverse. We get a former prosecutor who's a judge and you say, oh man, we're totally screwed here. But they're not, because they are sort of washing down or whitewashing some of their prior career by being more lenient on the defense now. And so when you see that in the Supreme Court and you say, we got these 3 judges, Trump appointed 3 different judges onto the bench, surely they're going to give him some sort of a benefit for those appointments. No, not, it doesn't surprise me at all. He put them on there. So now they've got to be really hyper concerned about the appearance of impropriety, that appearance of bias. And so they're not going to just go and say, yeah, sure, Donald Trump, yeah, we like Donald better because he nominated us, therefore he gets a vote. Just don't see that as happening. So not entirely unusual. A lot of people are sort of throwing their hands in the air saying, well, how is this possible? Well, that's how it's possible. They've got their lifetime appointment. They don't have anything left to prove to Trump or the Trump administration. They're on there forever. So they're going to vote and they're going to rule according to their own predispositions. All right, so that's enough on the Texas matter. Now let's talk about something else that is not fraud. Okay, it might be some evidence of it, but it's not fraud because YouTube said it's not. All right, this is the Allied Security Operations Group. This is Antrim, Michigan Forensics Report, which was revised. This is a preliminary summary which was released yesterday. I want to go through this a little bit because there's some interesting nuggets on here, and this is sort of making the waves around the internet. Now, these types of reports, these forensic reports, are pretty common in the law. We get these a lot in criminal law. We get these a lot on blood results, sex crimes. We have sex investigations that require a whole slew of expert reports and so on, drug crimes, gang crimes. So we're used to these types of reports. And this one is interesting because it comes from Dominion. It comes from the Dominion voting software, which took place out of Antrim County in Michigan. And we saw that. If you've been a regular of this channel, good time to subscribe. If you're not, we've been talking about Antrim. We've been talking about a lot of these claims for some time. And last week we covered a situation where a judge, I think Jenna Ellis from Donald Trump's team, indicated that a judge granted them access to go into Antrim County and do a forensic audit of the Dominion software. We now have a revised preliminary report, which was just released yesterday. So let's take a look at it. This is from an attorney, Matthew DePerno, and this report comes from a guy by the name of Russell James Ramsland Jr. He tells you about who he is. He says, I hold an MBA from Harvard University, political science degree from Duke. I've worked in the National Aeronautics Space Administration, so he's worked for NASA, and the MIT, Massachusetts Institute of Technology, among other organizations. I've served on a technical government panel. I've run many businesses that are highly technical in nature. And so he presumably is part of, this group. He says, I am part of the management team over at Allied Security Operations Group. ASOG, so we'll call it ASOG, is a group of globally engaged professionals who come from various disciplines, including the Department of Defense, the Secret Service, the DHS, so it's Homeland Security, and the CIA, provides a range of services, focusing on cybersecurity, open source investigation, penetration testing of networks, employ a wide variety of cyber and cyber forensic analysis, patents pending, variety of different security applications called SCADA, supervisory control and data acquisition, protection, safe browsing, so on and so on. Okay. For this report, I've relied on all of these experts and all of these resources. And so Ms. Faith did a very nice job, clipped out a couple things that I think are worth pointing out. So first and foremost, preliminary purpose and finding, preliminary conclusions. The purpose of this audit is to test the integrity of the Dominion voting system and how it performed in Antrim County in Michigan for the 2020 election. So it's one county in one state with one specific focus. That's it. The intention here is just to test the integrity of the software. They are concluding, not me, they are concluding that we conclude, this is from the security group, that Dominion voting systems is intentionally and purposefully designed with inherent errors to create systemic fraud and influence election results. The system intentionally generates an enormously high number of ballot errors. The electronic ballots are then transferred for adjudication. The intentional errors lead to bulk adjudication of ballots with no oversight, no transparency, and no audit trail. This leads to voter or election fraud. Their words, folks, their words, not mine. Based on our study, we conclude that the Dominion voting system, I cannot ever pronounce that. I have a little bit of a stutter on that word for some reason. We further conclude that the results of Antrim County should not have been certified. This is the breakdown of the votes that were tabulated in 2020 with different dates. November 3rd, you see all the different registered voters, total votes cast. We have Biden votes, Trump votes, third-party votes, and votes, total votes for president. All right. And that's the data. So that's what they're showing us. When we go over here, we have some additional conclusions that are coming out of this report. This is their information, not mine. The allowable election error rate established by the FEC, so the Federal Election Commission, their guideline says it's 1 in 250,000 ballots is an acceptable election error rate. So if you want to break that down into a percentage, it is 0.0008%. 0.0008%. We observed an error rate of 68.05%. Okay, so keep in mind where that decimal point is. The allowable rate established by the FEC is 0.0008. However, we have 68%, 68.05. This demonstrated a significant and fatal error in security and election integrity. Not even close. I mean, okay. The results of the Antrim County 2020 election are not certifiable. In paragraph 7, paragraph 8, the tabulation log for Antrim County from December 6 consists of 15,600 errors. 10,000 or 68 of those events were recorded errors. These errors resulted in overall tabulation errors or ballots being sent to adjudication. This high error rate proves that the system is flawed and does not meet state or federal election laws. Okay. Well, it doesn't matter because the Supreme Court doesn't care. Number 15 says, significantly, the computer system shows vote adjudication logs for prior years, but all adjudication log entries for 2020 are missing. You're kidding me. The adjudication process is the simplest way to manually manipulate votes. The lack of records prevents any form of audit accountability. Their conspicuous absence is extremely suspicious since the files exist for previous years using the same software. That's weird. Removal of these files violates state law. We must conclude that the 2020 election cycle records have been manually removed. Research is ongoing. They are finishing here in paragraph 22. It says, however, based on preliminary results, we conclude that the errors are so significant they call into question the integrity and the legitimacy of their results in Antrim County to the point that the results are not certifiable. Because the same machines and software are used in 48 other counties in Michigan, this casts doubt on the integrity of the entire election in the state of Michigan. That's according to this company, not yours truly. But let's keep talking about it. It says, number 6, the most preliminary report of serious election fraud indicators is comparing the numbers on both rolls. We estimate 1,474 votes were changed across the two rolls. Between the first and the second time, the exact same ballots were run through the Clerk County's total, which is almost the same number of votes, the same number of voters that voted in the total. Paragraph 7, there were incremental changes throughout the rolls. This demonstrates conclusively that votes can be and were changed during the second machine count after the software update. This should be impossible, especially at such high percentage to total votes cast. All right, we have for the school board member for Central Lake, there were 742 votes that were added to this total. And here it looks like a recount. So we have here the school board member for Central Lake Schools. We have Melania Eckhart, 852. Look at the number, the different, oh my goodness. Election 11-3, Melanie had 519 votes. Keith had 525 votes. On the recount, those numbers changed pretty dramatically. Melanie Eckhart now went up to 852. Keith went up to 846. So it actually changed the course. It reversed that election. On election night, 11-3, Keith Schaefer won by 6 votes. But on the recount, Keith Schaefer lost by 6 votes. Interesting. We have a number of new write-ins. So the total votes went from 1,068 on election night to total votes on the recount were 1,810 votes. So, all right. We have the Antrim County Forensics Report, folks. Some more evidence, some stuff that doesn't look so good. But once again, remember, that's their evidence, not mine. We're just talking about it here. All right. Let's go over to the Wisconsin Supreme Court. In Wisconsin, we had a order today, 2 orders actually, and so we're still trying to make sense of both of these, but Miss Faith clipped this one. She found a news article here showing what happened. Remember we talked about Wisconsin, largely we talked about this concept of indefinite confinement. So what's been happening around the country is the different people who run the elections, Secretary of Elections, Secretary of State, different board of elections, they write rules, and those rules get distributed across the precincts and across the counties so that people know how to vote. Well, in Wisconsin, what happened was there was this little bit of a modification where they took this idea that you can be indefinitely confined in your residence, which means you can't go out and register to vote. If you're in one of those buckets, if you're in this little category of votes, well, you can't go register to vote. So the law will carve out an exclusion for you to say you can register and we're not even going to check your identification. Don't worry about it. But the next time that you're not indefinitely confined, come in, then update your information and we'll make sure that you're registered according to our laws. Well, what happened because of COVID and the world melting down, in Wisconsin, they said everybody's indefinitely confined. You're all indefinitely confined. In fact, if you want to register to vote, here's a link to a website that was posted by somebody who works for the government, Scott somebody, and they posted that on Facebook and said, just go right on over to our website, hop on there, upload your information, skip section 7 because that's the one that asks you to upload your ID. We don't need you to do that because you're indefinitely confined because we said so. Therefore, just upload all your stuff. Things will be fine. We'll process your registration. Well, that's not what the law says. They're not really allowed to do that. So these issues worked their way up to the Supreme Court, and this new order came out today. So I haven't read the full thing with a little bit of a word of warning on this. Wisconsin Supreme Court says individuals can determine for themselves whether they can avoid the voter ID law because of age or disability. So, all right, the state Supreme Court ruled on Monday. It's up to you Wisconsinites to determine whether they face challenges that allow them to vote absentee without providing a copy of their photo ID. Under state law, people can vote absentee without showing ID if they can say that they are indefinitely confined. 2 county clerks this spring contended that voters could meet this status because of the stay-at-home order issued by Tony Evers, the Democratic governor. State Republican Party sued the state Supreme Court, and the clerks suddenly rescinded their advice. They said that initial order was faulty. In its final decision on Monday, the justices concluded that it was up to each voter, not clerks or anyone else, to decide when they qualify as indefinitely confined. In addition, they found that the pandemic and the stay-at-home order, which has since been struck down, did not render all voters indefinitely confined. So kind of 2 important things there, right? Number 1, if not every single voter was indefinitely confined, could you challenge those ballots? What about every single ballot that was cast under that provision, under that authority? Are they truly indefinitely defined? Or does this open the door for the Republicans to go in and challenge those ballots and say, okay, well, we want to look at everybody who was indefinitely confined. We want to call all those people and see whether they were truly indefinitely confined. The Supreme Court is turning around and saying, well, if they said they were, then they were. They're the ones who get to make that decision. And really, I mean, how can you argue with that, right? If somebody says, I didn't feel safe enough, I didn't want to go down there and vote in person, I didn't want to go, register to vote, somebody told me I didn't need to upload my ID, no problem. How do you argue with that? Well, it's too bad. We think that you were not indefinitely confined, and therefore we're going to throw your vote out. Sorry about that. Are they going to do that? No, they can't. They can't do that. They can't do that. I mean, it's an interesting order, but what's the remedy? What's the recourse? Can the Republicans go back and do anything with this data? Probably not. Let's take a look at the official document here. This is from Mark Jefferson, Republican Party over in Wisconsin, and the respondents. So they're suing Dane County, Wisconsin. Scott McDonald, that's his name. Scott McDonald was the guy who posted on Facebook that you can do whatever the heck you want. This was their order. They're saying that the petition for original action, they wanted a declaration. They wanted to say the government lacked the authority to issue what they issued, which was allowing those registrations to happen without photo ID. And number two, they wanted to basically say that the emergency order was invalid. So to answer these questions, they interpret the statutes, they go through it, and they're saying an elector is indefinitely confined. Accordingly, we conclude that the respondent's interpretation of the election laws was erroneous. Additionally, we conclude that order number 11 did not render all Wisconsin electors indefinitely confined, thereby obviating the requirement of a valid photo ID. So they're coming out and they're saying that, yeah, you've got to, you weren't actually indefinitely defined. So a little bit of a win, but not much of a remedy, because what are they going to do about it? Is Wisconsin going to change on this order? I just don't see it, because they would have to go back through and take that bucket of the indefinitely confined voters, if they could even find that bucket anymore. Then they would have to go through each one of them and one by one make those determinations, and then they'd probably have to make an argument and contact the voter and see what the remedy is for each individual voter. Okay, so you said you were indefinitely confined. This is what indefinitely confined means. Do you think you were indefinitely confined? No, I wasn't. Okay, so you weren't, so that means your ballot's invalid. We need more information. We need registration. We need a license. We need to cure your ballot to make it legitimate now. Or the alternative would be, we just don't count that ballot. Or we just say, did they get to re-vote again if they're properly registered? What's the remedy? We really don't know what the remedy is. And is it enough to change course in the Wisconsin election? We don't know. We'll see. We're going to see what happens as that ruling continues to be processed. And lastly, the news, as we were just getting ready to broadcast live, Donald Trump, as he likes to do at the end of the day, right before the show starts, he posted a new tweet on Twitter. And here is what he had to say. Just had a very nice meeting with our Attorney General, Bill Barr, at the White House. Our relationship has been a very good one. He has done an outstanding job. As per the letter, Bill will be leaving just before Christmas to spend the holidays with his family. He says, Deputy Attorney General Jeff Rosen, an outstanding person, will become Acting Attorney General. Highly respected Richard Donahue will be taking over the duties of Deputy Attorney General. Thank you to all. So this is kind of a big deal. The Attorney General, Bill Barr, somebody who we've covered a lot here, is not around anymore. He's going to be resigning, and he's going to be leaving office on December 23rd officially. So what does this mean? Well, let's take a look at his letter, because there are some interesting points here. This is the letter that he gave to Donald Trump. And so a couple things to keep in mind. At this meeting, was this a resignation meeting? Was this a meeting to discuss some policy changes? Did Bill Barr come into this meeting prepared to resign if they didn't come to an agreement? Did they sit down and say, hey, me speaking as President Trump, Mr. Barr, we want you to investigate electoral fraud. Mr. Barr says, not inclined to do that, Mr. President. Here's my letter of resignation. Is that how that happened? Or was this sort of a predetermined, have they had conversations about this? I don't know. Let's take a look at the letter from Bill Barr, and then we can speculate for a little bit, because that's what we like to do here. We have the Office of the Attorney General, drafted today, December 14th. Mr. President, I appreciate the opportunity to update you this afternoon on the department's review of voter fraud allegations in the 2020 election and how these allegations will continue to be pursued. Right there, right? What does that actually mean? We know what it says, but what does it mean? He went into the meeting to discuss voter fraud. He left the meeting, resigned. But he also says, we're going to continue to investigate the voter fraud allegations. So what is it? On the one hand, you can say he left the meeting and resigned because he did not want to continue to pursue the electoral fraud investigation. But he just says these allegations will continue to be pursued in the same letter. So what is he saying there? At a time when the country is so deeply divided, it is incumbent upon all of the government to do everything we can to ensure the integrity of the elections. Okay. I'm greatly honored you called me to serve in your administration. I'm proud of the role. Your record is all the more historic because you accomplished it in the face of relentless, implacable resistance. Is that how you say that word? Your 2016 victory speech, in which you reached out to your opponents and called for working together for the benefit of the American people. The nadir of this campaign was the effort to cripple, if not oust, your administration with frenzied and baseless accusations of collusion with Russia. So this is just a big puff paragraph. We don't get any information out of that other than, oh, this is, hey, Donald Trump, you're an amazing dude. Look at all this great work that you did. So nothing to glean from that other than this is a very nice letter that's supporting Donald Trump. Few could have weathered these attacks, much less forge ahead with a positive program for the country. He built the strongest, most resilient economy in American history. Did Trump write this or did Bill Barr write this? You have restored American military strength by brokering historic peace deals. You've curbed illegal immigration. You've advanced the rule of law with Operation Warp Speed. You delivered a vaccine for the coronavirus. All right, during your administration, the DOJ has worked tirelessly to protect the public and so on. The Mexican drug cartels. We've cracked down on China's exploitation of the economy. We've defended competition in the marketplace and so on. But again, not much there. Not much there in terms of why he's leaving. As discussed, I will spend the next week wrapping up the few remaining matters important to the administration. I'm going to depart on December 23rd, wishing you, Melania, and your family a very Merry Christmas and a blessed holiday season. So not a lot of information there, actually. The only thing that we can really kind of pull from this is that first sentence, which we're going to go back to right here. It says, I appreciate the opportunity to update you on the department's review of the voter fraud allegations and how these allegations will continue to be pursued. That's it. It's kind of really the only meat out of this entire letter. So what can we take from it? Well, some initial thoughts on it are as follows. Let's go through and let's play the speculation game a little bit. I've already talked about some of the possibilities. So number one, Barr quit to free up the position for the next administration, right? And this can be something that is just as simple as it sounds. Barr figured he's done with this role. He's brought in, he's been at the DOJ, I think for most of his career, right? He's been there a very long time. And today was Electors Day. He said, okay, well, today there's kind of the conclusion of the election. All the electoral votes were cast for the Electoral College. It's done. It's over. No coincidence that it's December 14th. He just decided, I'm done. Turned in his letter of resignation. Simple as that. They parted as friends. I think that largely they probably were friends. And I'm not of the mindset that, today is a good day to dump on Bill Barr and by any stretch of the imagination. I don't have any real problems with the guy. I know a lot of people out there in, certain segments of the internet world have been very upset with Bill Barr for not, being overly aggressive with the prosecution of certain things. And, Bill Barr to me just kind of felt like a straight shooter of a guy, somebody who I remember during his judiciary Senate or House hearings, we covered him on this program. I forget what he was testifying about at that time, but kind of just a by-the-book guy. I remember Eric Swalwell asked him, are you investigating the Russians? Are you investigating Donald Trump for the Russians? And Bill Barr said, no. And Eric Swalwell said, why not? And he goes, why should I? And he just had another drink of water, with his little pinky up, Bill Barr. So, I kind of liked his style. I liked how he approached a lot of things. I think he was kind of a by-the-book guy. He did not seem somebody to me who was overly influenced by Donald Trump, which I think is a good thing at the DOJ, a little bit different than what we saw out of Eric Holder and Obama. That relationship there was a lot more like bros. I think Eric Holder even said something to that effect, like, he's a quarterback, I catch the ball, or something like that. There was some sort of an analogy there that I thought, is that how that's supposed to work? I don't think so. And so I think Bill Barr operated with a little bit more independence and a little bit more, I think, autonomy away from Donald Trump and his administration, which is a good thing. You don't want a politicized Department of Justice. I don't care who the president is. You don't want that to happen. You don't want political prosecutions. You don't want investigations into your political enemies. You don't want that. And I think Bill Barr kind of, navigated those waters with some grace, if you can call it that. So this may just have been the end of his tenure. He just said, I'm done. Enough of this stuff. I'm out. The next president's confirmed. We don't know who it is, and I'm bailing. Could have been that. It could have also been something a little bit more substantive. We're talking about some policy disagreements. So couple of the ones that came to my mind initially were, one, Edward Snowden and Julian Assange. The idea here being that Trump is getting closer to the end of his term, and there is this idea that he's going to, pardon some pretty controversial people, Edward Snowden, Julian Assange. Some idea here that he's going to declassify a bunch of really, important information that I think a lot of Americans want to see. They could have just had some disagreements over that, and Bill Barr just said, all right, listen, you're going to do all those things at the end of your term. I don't want any part of it. I don't want to be associated with any of that stuff. I'm out. I'm bailing. Also with the election fraud stuff, he could have said, Donald Trump could have sat him down and said, listen, need you to really look at this stuff. Are you willing to do that? And Bill Barr said, no, I'm not. I've looked at it. I know you don't like the answer. Sorry. This is where we have to part ways. So it could have been a policy disagreement on that. And the final one that I was thinking about was this Hunter Biden stuff. The Hunter Biden stuff has been around for a long time. The John Durham investigation has been going on for a long time. And largely we haven't seen anything out of it. And I think Donald Trump is probably seeing a lot of this, Burisma news. Hunter Biden has confirmed he's under investigation. There's been more evidence, more, leaks and more information that the FBI is continuing to probe this stuff. And so Donald Trump may have just sat him down and said, listen, I want you to appoint a special prosecutor. I want this to carry over into the next administration. And Bill Barr just said, no, I'm not going to do that either. And so we are done. We're done. Closely related to that, Donald Trump could have fired him, right? He could have just said, listen, it's time for you to go. I need somebody who's going to do more of the things that I want to get done in terms of policy. And we're going to see if this acting Attorney General is going to implement any of those policy changes. So for the next, 3 weeks or so, going to keep a very close eye on what's happening at the DOJ. Are new investigations starting? Are new charges being filed? Are there any major policy changes that are happening? Remember, we saw that Attorney General Bill Barr released a public memorandum to the entire Department of Justice that we read here on the program, where we talked about what his threshold was for election lawsuit and election interference prosecutions. Came through. I thought he actually gave some pretty clear and reasonable guidelines for the rest of the DOJ to follow. And Donald Trump may not have liked that, right? So we'll see if the next acting attorney general, if they're going to come in and make some of those changes, then that'll be a pretty good indication of where this stuff is going. Donald Trump fired him as a scapegoat to satisfy the critics. So like I said, a lot of people here are very upset at Donald Trump for not doing more in terms of managing the executive branch of government. Largely Donald Trump will get on Twitter and he'll say, somebody should do something about that. And then everybody scratches their heads and they go, wait a minute, aren't you the president? Don't you constitutionally have the explicit authority to do something about that? And you're saying somebody else should do something about that? It's been one of my criticisms actually for quite some time here. Stop saying that somebody else should handle all this stuff. You just do it because you're the president. You're literally the most powerful person in the world. I don't know what you're talking about. But the point of those tweets is just raise awareness about it. It looks bad if he starts acting like a dictator, but it's kind of incongruent when you're complaining about something that you have the authority to fix. It just doesn't make a lot of sense. And so people have had some criticisms about that, and I think some very valid. So the idea here is that they got rid of Bill Barr as a scapegoat so that Donald Trump can go back to his base and he can say, listen, I got rid of Bill Barr. That nothing wasn't doing anything. So we fired him. Maybe the next person will come in and make some changes. And it could be something else. There could be something else that we're missing here. I'm not putting that past myself. So the last two things I wanted to talk about, he is going to be in office until December 23rd. So there's still some time there, right? He's still got a couple weeks left. And it's interesting that he wants to go home and spend time with his family, but he's not leaving until the 23rd. So not that much time. Probably just about Christmas Eve and Christmas Day. Then he's back to doing Lord knows what. So, this holiday excuses doesn't carry much water in my mind, but he's going to be there until 12/23. Why is that? Remember, the executive order report that we covered, the 2018 executive order that mandated that there's going to be a number of different reports that are due back to, I think it was the DNI, the Director of National Intelligence. I think that is Ratcliffe. I think if I remember the EO correctly, all of the reports go back to that individual. One of the reports is supposed to come from the DOJ, if I'm not mistaken. Department of Homeland Security, Department of Justice, Secretary Treasury has a report. I think, the other alphabet agencies, CIA, FBI have reports that are due back to Ratcliffe by December 18th. So Bill Barr may be wanting to stay just to sort of encompass that, or, keep the umbrella over that issue. And then today, we didn't even talk about it, but this SolarWinds stuff, this bombshell that this, still making sense of it right now, but there's some allegations floating around that there was a major breach of data. There was this supply chain hack where these hackers from some foreign source, whether it's the Russians, the Chinese, everybody's pointing their fingers at each other right now, but this idea that they were able to infiltrate the supply chain of some major software, which means they built in essentially a backdoor in the production line that was carried into production. And so this software is deployed across a number of different agencies, including some major federal government agencies, and potentially even Dominion and some things like that. So that's a big deal, right? If a foreign power got access to mountains and mountains of data, the Bill Barr may want to he may want to stick around a little bit until some of that gets concluded. So we will see. Now, let's head on over to some of these super chats. We have Uncivil Law in the house who says, here is how Bernie can still win. So I think he's poking fun at us over here. I think he's, giving us a little bit of a needle, saying that we're like the Bernie bros who said that Bernie was going to win. I think they still think he can win. There's probably a pretty sizable portion of that who says that if we take this Rubik's Cube and we put it under this thing here, and we take that and we screw on this here, maybe Bernie can still win the presidency. Maybe he can. Thanks on Civil Law. Appreciate that. We have Sharon who says, could you please explain the situation in Michigan with the electors being locked out of the state building? Isn't this a violation of due process? Good question, Sharon. Probably not. I mean, I think that, any of those types of issues that involve due process, you have to be denied access to something that is a constitutional right, or so you have some sort of entitlement to that. Here, the argument would be, no, they aren't the official electors. They're not allowed to go in and cast their votes because under state law, they didn't win. So I would think that they should be, or I think they can lawfully be excluded from the building. Just like we saw in Nevada, they were probably excluded themselves, and those votes, or they cast their votes literally on the sidewalk outside of the building. So I don't think that there's probably any due process violation there. Let's take a look at some other ones coming in. We have Rolly Murray who says the concept of standing was created in 1922. It is not in the Constitution or the law, just a way to dodge cases. SCOTUS, get a spine. Eric Holt, there he is. There it is. Rolly in the house with, man, Rolly is the man. He says, Eric Holder said, I'm still the president's wingman in 2013. That's the analogy that I was thinking of. I knew that there was that really kind of close, hey, we're just hanging out. Anything you need, I got you on that. There was that relationship. And I didn't think that was very healthy at all. And yeah, Rolly's right? The concept of standing created in 1922, it's not in the Constitution. He's right about this. Standing, mootness, ripeness. I think there's 5 different doctrines in constitutional law that we spent a lot of time talking about that just kind of the courts just sort of created out of nowhere. And there are other attorneys. I actually heard Robert Barnes talking about this last night, where he was saying he's very anti-standing. And he was saying that, if an attorney talks to him about standing, he thinks that attorney's, a little bit not so good. So he's got a little bit, I think, more of an extreme take on it. I do think that standing and ripeness and mootness, I think there's, some applicability, or some, at least from a logical perspective, you can look at those legal concepts and you can say those make sense. And I think they do, but not when you use them on an issue like this, not when the Supreme Court says, listen, we're just not going to entertain the case. We're going to find an excuse and we're going to call it standing, right? Even though I think 16, 17, 20 something states joined in on it. A number of attorney generals, Congress people from all over the place. I mean, this is what the Supreme Court is really for, in my mind. It's to deal with these issues, and they didn't want to do it. All right, we have another one coming in from Lava Java Lava with a nice little super chat sticker there. Thanks, Lava Java. Appreciate you being here. Good to see you, my friend. We have another one that came in from Will. Does Trump's electors have to be appointed by the respective state's legislature, or does that not matter? So, yeah, good question, Will. I think that's going to be on an individual state basis, right? Each different state has their own rules. I know that some states, they have provisions in their laws when it comes to, filling out the votes of or the certificates of ascertainment, where they say specifically that if you don't vote the way that the state voted, you are kind of immediately revoked of your power to be an elector. So, if I was elected, or if I was nominated to be a Joe Biden elector, and I went in there and I just said, no, I'm not going to vote for Joe, I'm going to cast my ballot for Trump, according to those local state statutes, my power would automatically be revoked. If I start writing the D for Donald, that's it. It's the end of the game, right? I'm breaking the law, and the law acts with an automatic revocation of your power. And that would be like, that would be in the situation that we're talking about right now, where they didn't win, but they're going to go and cast their votes anyways. And so I think, for your question, the people that we're talking about here, the Republican GOP nominees, they are not approved. They are not appointed by their respective states. They would have been if Donald Trump would have won their states, but he didn't, allegedly. So now they're no longer approved. They're no longer official electors anymore. They're casting their ballots anyways, on the condition that if something happens, they will now sort of re-urge their votes. They're going to bring their votes back, and they're going to use those because they're going to say that Biden's votes were illegitimate, unlawful, fraudulent, whatever. Those votes get thrown out, and they should replace those with the votes that they've already casted. All right, we have another one. Ron B says, well, the Wisconsin Supreme Court acknowledged that the Secretary of States and county clerks overstepped their means to change the law, but they dismissed the case. Your thoughts? Yeah, Ron, we covered that about 30 minutes ago, I think. And, I think it's exactly right. They ended up saying that this indefinite confinement thing is not legitimate. You can't just, with a broad stroke of the pen, declare the entire electorate indefinitely confined and then base that indefinite confinement on COVID. So the governor passes an order, says, okay, we're all on lockdown. The Secretary of State issues new rules and says, okay, we're on lockdown, therefore you're indefinitely confined. Therefore, all of the original legitimacy checks that we had in our electoral process, those are out the window. Any voter verification, any upload your ID, none of that stuff matters anymore, because we're under this new governor's order, which allows me to use this indefinite confinement rule, which allows you to go and register to vote without any ID. So it's just kind of that trickle down effect, that snowball's rolling down the mountain. And here they're saying you really can't do that. But it's too little too late, because the remedy here would be to go back and ask every voter, or investigate every voter, to see whether or not they're indefinitely confined, and then make claims about each individual vote. And the Supreme Court also, in the same opinion, came out and said that each individual voter can determine whether or not they're indefinitely confined. So not a lot of standards to follow, kind of messy, which is why it would have been nice if the Supreme Court had said something about how all this should be working. Jamie Goodson says it's a chess game. It's a chess game, not a checkers game. And Jamie Goodson, you have a lot of people, and you're in good company. There are a lot of people out there who are agreeing with you and with that. We have Aaron J., who says, if there are multiple states being contested at the joint confirmation session and they have the required 2 signatures, do they have 2 hours for each state, or do they work it all at once in the 2 hours? It's a good question, Aaron. I don't know the specifics on that. The only window that I've seen is 2 hours. So I don't know how that works. And, this is where a lot of this procedural stuff becomes nuanced and very, very nitty gritty. And I'll be honest with you, I'm not sure that most Congress people know what the answer to that question is. A lot of this stuff has never been used before. So it's just written down in the rules. But as a matter of practicality, it's your guess is as good as mine. You can play it out both ways, right? If it's 2 hours for every single objection, couple objections in a couple different states, you get Joe Biden's electoral vote numbers under 270. So if a bunch of Arizona objects, Pennsylvania objects, Georgia objects, I think that's enough, right? So it drops him back under the 270. If it's the 2 hours and, they go in on each one of those at 6 hours, you could think that they could go and resolve those in a day, no problem. They come back out and vote. If they still can't agree on those votes, Joe Biden stays under the 270. Arizona, in Arizona, Georgia, whatever I said, those don't count. Joe Biden's total electoral vote threshold drops below the 270. If there's no agreement, then that will trigger a contingent election in which the House of Representatives ultimately votes. So it kind of doesn't matter. Now, if you had 30 states that were all objecting to all of those different states, you could see about a time delay. If you have to deal with them all at once, you could have some negotiations going on. All right, we're going to count those, not count those. We'll see. It's a great question, and we're all sort of learning this thing as we go along. It's why we're so grateful that you're here. We have Wolfgang Deo who says, hi, Rob. Hi, Faith. Hi, all. Good to see you, Wolfgang. Thanks for being here. We have Alil Adams who says, libertarian lefty here again. We missed you last week. Just wanted to say that it's funny how the dictator Trump story is falling away, but the paranoids are still yelling. Yeah, it's a good point. It's a very good point. Eliel. What a name. That's a great name. Thanks for being here and being a part of the program. And I think you're exactly right. I missed you too, by the way. You know, I was missing the live streaming for sure. It was a weird feeling. I was like, I have so much to say about these things and I can't talk about it. So I don't think we're going to do that again. I told Miss Faith, we're not doing that anymore. This is where I need to be. And so it's good to be here. But to your point, it is very interesting, right? We've been hearing for a very long time how Trump is going to institute martial law and take over the country. And I just keep missing it. I don't know why. You know, you would have thought he would have done it some time ago, but these deadlines just keep coming and passing and things still are carrying on. So maybe some of that stuff is hysterical. Thanks for the super chat, my friend. Good to have you back. He sent another one over here. It says, at the same time, big tech is looking more and more autocratic every day. 100% right on that. You know, I was talking to my business partner, Ryan, about this, and it's funny, you know, the big tech has a lot more power and control over you than the government has, right? The government, you've got a lot of protections, freedom of speech. It's in you got the whole Bill of Rights. You have a whole ton of rights in there that big tech doesn't afford you. The government is less dictatorial than, you know, the government doesn't control what I say. YouTube does, though. All right, let's take a look at the Digital Soldier. Give us a thumbs up. Thanks, Digital Soldier. Appreciate you being here. Right there, we have another one from Ikari 2000. It says, can Pence hand out binoculars to Democratic observers, kick them out, and then count the Electoral College votes privately? Oh, gosh. What a great comment. Brilliant. Yeah, absolutely brilliant. Yeah, it's true. And apparently he doesn't even need to check the signatures either. Just count them all in. Come on in. Yeah. Yeah, that one looks pretty legitimate to me. Looks good to you. Hey, does that look good to you over there? Looks good to me there, Mike. Count it. Throw it in there. Good. Hilarious. Thank you for that, Ikari. We have Lawrence Al, who says, thoughts on the federal execution of Brandon Bernard and Alfred Bourgeois of last week, and the two executions are set to come before January 20th. Lawrence, I do not support the death penalty in any sense of the word. I think that when we fast forward humanity in 20 years from now, we're going to look back on the death penalty and we're going to think that that was something very barbaric and very inhumane, but also inhuman. You know, it's one of those things that we do that I think is nostalgic. It's a carryover from the earlier days of the administration of justice, where we didn't really know what to do with people. We just thought, that guy's a bad guy. He's an evildoer. He's, you know, somebody who is just beyond repair, beyond any recourse. And so the only thing that we could do was just kill that person. I don't think that that is appropriate anymore. I think that we have a good understanding of people now. And I think we understand largely why people are the way they are. I think a lot of it has to do with past trauma, past, upbringing. And there's a lot of other reasons that a person is the way they are, rather than them just wanting to be evil. There are evil people for sure. I've worked with them. Okay. I'm a criminal defense lawyer. I've worked with a whole range of people. I will tell you that the vast majority of people that we work with are very good people. The justice system executing people, in my mind, it's just not appropriate anymore. I think it's going to be looked at like barbaric, like very barbaric, almost like we look back at how the Colosseum was, back in the Roman days. Wow, they did that? That's crazy. Because I just don't think it's appropriate. Now, I understand and I empathize with a lot of the plight of the families of the victims. I get it. I understand that. I don't think that retribution, wanting to see somebody else killed, is necessarily a good way to heal if you are the victim of a horrendous crime like this. And I'm not wishing that upon anybody. But seeing somebody else killed does not bring your loved one back, does not make you whole. I think the better way is to find some forgiveness in your heart. It's to find a way to move forward, to deal with your grief. I've had the unfortunate experience of losing somebody, not as a result of a crime, but I know the grief process. I've lost somebody very unexpectedly, and I know what it is. Me going off and doing something is not going to bring that person back, or me trying to take vindication against the person who sold my brother drugs. That's not going to help anything. It's not going to change him. It's not going to bring him back. And so for me, the healing and the grief process has been about, sort of acceptance and understanding that and unwinding sort of the layers of my personal onion to find out, what am I really upset about? What am I really grieving over? Why do I miss him? Why is this so difficult? And coming to terms with that. And so I think that is probably the better prescription for people who have lost somebody, rather than just saying we want to execute that person and come to the idea or have the belief that that's going to fix them, or that's going to make them whole, or that's going to bring their loved one back. I don't think that's going to happen. And I also think that procedurally, we've killed people who should not have been killed. Okay. And it's a mistake that you cannot recover from. I think the death penalty has led to the execution of people who should not have been executed, probably because they didn't commit the crime. And I think that there's enough documented evidence that that is not just a one-off anomaly. It happens probably more than anybody would like to admit. And if you are a fiscal conservative and you're somebody who says, well, justice and all of those things, yeah, it's pretty expensive too to put somebody on death row. I think it's something like 10 times the total cost of housing somebody in prison for life because of all the appeals and all of the procedures that goes on. It's extremely expensive, and it's a mistake, or it's an action that you cannot come back from. It's done and over. And so I would like to see the abolition of the death penalty across the board. I do not think it is in the interest of justice. The idea that it's a deterrent effect, I think, is a little bit bogus. I understand the argument, but I do not support it. And so I would really truthfully like to see those other executions vacated. I would like to see that not happen. But under this current administration, I'm not sure we're going to get there. A good question, though. Ron B says, yeah, Mr. Putin came out today and denied that Russia had involvement in the U.S. Treasury. Yeah, so you're going to see a lot of this. And I thought this was kind of interesting. You have a lot of, all of the different bad guys around the world. They're all pointing their fingers at each other. And the media is going to pick the one that they've already been talking about. So, the more and more, suddenly it's just Russia collusion again. More Russia collusion. Russian collusion all over the place. They're going to see it ad nauseum, probably for the rest of your life. But nobody wants to talk about, some of these other actors that we've had confirmations that they're trying to infiltrate our system. The Iranians, the Chinese, and so on. But they're going to just point their fingers back over at the Russians. Another one here from Ron B says, there were two there from Ron. Same question. We have S. Love, who says, didn't Barr release a Mexican official we finally arrested this year for no reason after we spent a boatload of taxpayer dollars to investigate and had ties with the cartel? Why? That Barr was a POS. So S. Love, I don't know what you're talking about, actually, specifically on that one. A Mexican official finally arrested this year for no reason. He was released. I missed that story. I don't know anything about that, but I will take a look at it. Regardless, I can't really, consider Barr to be a POS. I think he's, probably a pretty reasonable guy on the face of it, and I wish him well in retirement. We have Ty, who says every single Republican who signed out of the Supreme Court case should be rejected for violation of the 14th Amendment and put down for treason. Justice time. That comes from Ty. Ty, little bit aggressive on that one. Just a little bit aggressive on that. I think what the Republicans were doing is they were signing on to a letter that was literally going in front of a Supreme Court, that was going through the proper channels of our justice system. I think they're entitled to do that. 14th Amendment, not sure what you're talking about. Equal protection, you're talking about due process. There's a lot in the 14th Amendment, but I think that they had good arguments to sign on to that, and I certainly wouldn't want to put them down. I'm not sure what that means, unless you mean for a nap. A lot of these Congress people are pretty senior. They could probably use a good nap. We have Joel Lowry, who says, if the NDI 18 report comes back with foreign fraud interference, which seems easy considering the latest hacks, what action could Trump take? Great question, Joel. Very good question. So if you read through that executive order, you're going to find that a lot of Trump's remedies come in the form of being foreign relation powers. So the president doesn't have a lot of authority to just come into the United States and start executing different procedures, policies, new rules for the country to follow, because he's the president. He's the executive. He's the enforcer of the laws, but he doesn't pass the laws. Those laws are created, written by Congress. So when we're talking about domestic issues, those come through Congress. They pass the laws. The president executes the laws. The courts decide what the law is. They say what the law is, whether it's constitutional or not. If it's unconstitutional, they throw them out. That's it, right? Those are the only powers of the presidency. A lot of what the president does through these executive orders, through these sort of, executive fiat. I have a problem when Trump does it. I got a problem when Obama did it. I think what they're doing is usurping some of the power from the legislative branch, which is the branch of Congress. But the president does have essentially almost full autonomy in a lot of these matters relating to national security and international relations. So when you read that executive order, the one that he passed in 2018, one of the big mandates was by December 18th, all of these different intelligence agencies have to draft a report, send it back over to the DNI, and then he goes back and says what to do about it at that point in time. The executive order itself specifically also talked about some of the remedies that Trump has relative to the other foreign entities. So, for example, he could maneuver some trade deals, or he could cut off financial access to the United States markets. He could, sanction them. He could embargo trade with them. There's a lot of those international relationship powers that he could execute as a result of that executive order, but not a lot of it that I read, at least when I read through it here. And we covered that executive order, I think, in depth on this channel. I forget how long ago it was. It might have been even before the election. But he can't do much here domestically, but he can do a lot foreign, in foreign regards. Because the idea of passing the executive order was the Russians and other foreign agencies were interfering in our election. So the only remedy was against those foreign agencies. It's not here. He's not going to be able to use that order to come and sort of, throw out the election, because that is a domestic issue. Good question, Joel. All right. We have Rolly Murray, who says, please post to Rumble after the show. They should have live streaming early next year. All right, Rolly, that's it. Because you asked, I'm going to do it. I'm going to upload this program tonight on Rumble. The last time I did it, it took 7 hours. And so I said, I'm never going to do that again, but I will flip around right there and I will upload it on Rumble, because you and many others have asked that we do that. So I'm happy to do that. So we'll start adding the link onto our description so you can follow us over there when we get that up. All right, a couple more I see came in. We have one from Tyler Stokes, who says, what happens if on January 6th, neither candidate has 270? I've heard it's some sort of a contingent election in the House where each state gets one vote. Exactly right, Tyler Stokes. You have hit it on the head. So you're exactly right. If neither candidate gets to 270 electoral votes, it's a contingent election. And we also covered that a lot on this channel. There's a very interesting document you can find if you Google Congressional Research Service Electoral College. I think if you plug that into Google, you'll find it. And it's a 3 or 4 page document that details all, or actually, no, don't type in Electoral College, type in contingent election. Congressional Research Service contingent election. There's 2 different documents. The contingent election one goes through all the history of how this stuff works. Actually very fascinating. I would encourage you to read it if you're interested in this topic. But if you go there, you'll read, and that's exactly what it says. If they cannot get to 270, so if there are objections made when they're counting the certificates of ascertainment, then they're going to break. They're going to go in. They're going to have a debate, conversation for 2 hours. They'll come back to the floor. If they have enough people from both parties and enough states that they want to invalidate the votes from that state, they could theoretically keep Joe Biden under 270. If time expires, that would trigger the contingent election. Each state gets one vote. Donald Trump has more Republican states than Joe Biden does. So each state, one vote. Donald Trump wins. He becomes the next president based on the contingent election. We have Nathan Stone, who says, can you explain what role the vice president plays in a situation with dueling electors? So Nathan, it's a good question. Honestly, my interpretation of it is not much. I mean, practically, he's a figurehead. He is a procedural person who's sort of there literally opening the certificates of ascertainment, the documents that come in from the states, opening those, handing those to the teller. The teller is then the one who's tabulating those, counting those votes back, passes the total formal list back over to the president, the vice president of the Senate, which is Vice President Pence. He reads it, formally announces it, just like we have played in the previous clip on this show today, where he is hitting the gavel. That's it. It's sort of a procedural figurehead at that point. He could do anything he wants. You know, Vice President Pence, I guess, could say, I'm going to make a statement. I'm not going to accept these votes. I'm opening this vote. but I'm not going to hand this batch of votes to the teller. I'm just going to hand this other batch of votes to the teller. I was delivered this vote from the GOP out in Arizona, and I'm going to hand you those votes instead of the formal votes. Now, I don't think Vice President Pence is going to do anything like that. I just don't. Number one, he's extremely methodical, very, very well, I would say, orchestrated. He conducts himself well. We saw that this election. We've seen this entire administration. I've seen indications that he's not joining a lot of these Trump lawsuits for a reason. He doesn't want to be associated with that anymore. I fully believe that he's got presidential ambitions. So I don't see him as being somebody who goes onto the floor of the House of Representatives and opening votes that came from the state and then suddenly invalidating those. I just don't think that's realistic. I know a lot of people out there are sort of getting excited about that prospect or even that possibility. I just don't think that it is particularly likely. Good question, though. We have Stephen Baker who says, let's see, I'm sure you went over it already, but can you recap the Michigan lawsuit? Thanks, man. Great show. So, Stephen, we actually didn't cover the Michigan lawsuit today. We covered a little bit of Wisconsin. We talked about the Texas lawsuit being dismissed. The news today was at a breakneck speed, and I'm sure you probably would agree with me on that. So there's been a number of lawsuits that came out today, a number of lawsuits that were, I think, filed today. Sidney Powell and some of her people on her team filing all of these emergency motions in front of the Supreme Court. Today was everywhere because of the deadline. Everybody's trying to get stuff in before the deadline, appealing, and so on. So I'll take a look at the Michigan lawsuit. I'm gonna try to have an update for you on that tomorrow. No promises on that, but it is interesting. Basically, what we're trying to do now is identify any activity in the election process that has some, I would say, interesting new developments in it. A lot of the lawsuits that we've been covering up until this point have been kind of the same thing. Copy and paste, same issues. If there's something new on the lawsuits or there's a new order or a new ruling like we saw in Wisconsin, where today they talked about the indefinite confinement, but they said you can decide if you're indefinitely confined, so it's kind of a win, but kind of not. Those types of issues we will continue to discuss on this program. We have Ron B, who says, thanks for the love tonight. Welcome back, Rob. Thanks, Ron B. It's good to be back, my friend. I'm serious about that. It was I was missing it. I was missing the program, so I'm grateful to be back here. We have our last one of the day. We have one from Kenneth Fielder, who says, SCOTUS were afraid to hear the case due to violence. And that's another good point, right? That's another practical point that I think is relevant. When we're talking about SCOTUS and what do they do, remember, they are the Supreme Court. They set the policy. So what they say will trickle down to all of the other thousands, literally thousands and thousands of courts around the country. And if they would have granted certiorari here, which I wish they would have, because I would have liked to have seen some new substance. I would have liked to have seen what their decision was. It would have been interesting for me as a lawyer and as somebody who studies these issues, but I also understand why they didn't. I understand that if they did, it could, it really could kind of open Pandora's box. They could be states suing each other for all eternity. It could be, it could get kind of legally ugly. And the other side of this, the other component too is, there's a lot of people really upset about this stuff. And if they feel like this election is stolen from them one way or the other, it's not good. It's not good for the country. And so what the Supreme Court may have been doing is just calculating and saying, look, most of the country is sort of on the train. We're already moving past this issue. We're not going to entertain it any further. And we're seeing that around the country. We're seeing that with YouTube. They don't want to talk about it anymore. We're seeing it with Twitter. They don't want to talk about it anymore. Supreme Court doesn't want to talk about it either. So, for those of you who are upset about the Supreme Court, I am too. I think it's a little bit frustrating that we didn't get more guidance from them. I think, this is kind of where they make their money on issues like this, and they just booted it down the road, which means we are going to revisit it again in the future for sure. So I think that was the last chat that came in for the day. So my friends, let's wrap it up right there. I want to thank you so much for being a part of the program. As I said, it's great to be back here with you. We are going to be broadcasting live every day moving forward, at least during the week, not on the weekends just yet. So we'll be back here tomorrow at the same time. It's going to be 4 p.m. West Coast, 5 p.m. here in Arizona Mountain Time, 6 p.m. Central, 7 p.m. on the East Coast. A couple quick reminders. I'd love it if you subscribed. We're really close to that 6-figure subscriber number. I'm super excited about that. I've been making videos on this channel for 5 years now, and this year has been a lot of fun. We've been growing quickly because of these issues. There's just so much to talk about, and we're right there. We're so close, and I would just love it if you would help us reach that goal. It'd be a big help and mean a lot to us. Another way to help with that is to share the channel. Give us that thumbs up. It throws this video up in the algorithm. Google will recommend it next and give it a suggested next video. That's always appreciated. Want to invite you to join us on Discord. That's where the chat takes place before and after the show. We're going to put a copy of all of our slides in over there as well. If you want to grab a copy of my book, please feel free to do that. There's a free copy in the Discord as well there. So you can get the PDF of this book. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. Get that in focus right there. Written by yours truly. So you can see me there. Yeah, okay. And it's got some stuff in there that you can take a look at. The free copy right in our Discord server for you to join and get for yourself. And so it looks like, let's do one more super chat that Miss Faith just sent over. It says here, in regards to SCOTUS not hearing the Texas lawsuit, what is their first priority as Supreme Court Justice? What is their first priority as Supreme Court Justices? It's a good question. I think that largely it is to follow the Constitution. I mean, that would be my operating document, but I don't know what their priorities are. I think they all probably have many different priorities. One of them is not helping us answer election questions. That I can tell you. They're not even trying. They just said, no, it's no standing. We're not going to hear it at all. So that was that last super chat from Isaac Castillo. Thanks a lot, Isaac. And we will leave it at there. Before we sign off, I want to remind you one more time, my day job, what we do here is my firm, we have a whole amazing team of people here, is we help people charged with crimes. I mean, that's what we do on a daily basis. This show is just something that it's fun. I'm very interested in this stuff. I love being here and talking with you, but every day, what we're doing is boots on the ground, helping people through the justice system. It's representing good people who had a bump in the road. They need a little bit of help to get things back on track. That's what we do. That's what we're passionate about. We're very good at it. And so if you know anybody in Arizona who has been charged with a crime, an active case, an old case they want to clean up, an old warrant that they want to start in 2020 fresh with a clean slate, please send them our way. We're very good at what we do. We offer free case evaluations, and we would be grateful and honored for your referral over to us. And so that's it, my friends. I want to thank you one more time for being a part of this broadcast. We will be back here tomorrow, same time, same place, and I hope to see you there. Everybody have a wonderful week and a wonderful evening. Until next time, bye-bye.